Search and Seizure Overview Presentation by Ashley Delano. This presentation will outline the definition of the Fourth Amendment, the Supreme Court standard, and examples of search and seizure cases involving drug tests, mass or random drug testing, strip searches, random locker searches, metal detector searches, field trip searches, and a landmark case. The Fourth Amendment is defined as the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures, shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. The Supreme Court standard for searches by educational personnel of individual students requires reasonableness under all circumstances, whether circumstances justified the action, and whether the scope of the search was reasonable in relation to the situation. The first case to be reviewed involves drug testing and random drug testing. A school district adopted a policy authorizing random drug testing of student athletes. There was a known drug problem in the school district. Student athletes were among the drug users as well as the drug dealers. Along with the drug problem came serious student behavior issues. By 1989, disciplinary actions had reached epic proportions, motivating the district to introduce the student-athlete drug policy. James Acton, a 7th grader, refused the testing, and his parents refused to consent to the testing. Because of this, he was not allowed to participate in football. He sued the school district for violating his rights. The court ruled the drug testing policy is reasonable and does not violate the Fourth Amendment rights of the students. Students do have rights at school, but those rights must be balanced with the school's responsibility to provide a safe learning environment. The next case to be reviewed involves a strip search of a male high school student who was suspected of crotching drugs while at school. He was ordered to remove all his clothing, and school authorities visually inspected his naked body. No drugs were found, but the search was upheld as reasonable due to the fact that a school can perform a strip search on a student if there is any reasonable suspicion or cause for concern of an illegal item, or if it is in the best interest of the school. The next case to be reviewed is another strip search involving 2 second-grade students who were strip searched after being accused of taking a missing $7. The court did not rule on the reasonableness of the search, but did state that damages would be awarded because school officials would not necessarily have known that the search was unreasonable because there was no precedent in either Alabama or in the 11th Circuit. The next case to be reviewed is a locker search. After observing numerous occurrences of what appeared to be suspicious student behavior, administrators at Harbor Creek High School in Erie County requested the state police to conduct canine sniffing of student lockers. Drugs were found in only one of the 2,000 lockers searched. Drug paraphernalia and a small amount of marijuana was seized. The student was called to the principal's office and read his rights. Overturning a state superior court decision, Pennsylvania Supreme Court maintained that this search was reasonable under the federal Constitution and Article 1 of the Pennsylvania Constitution. The court pointed out the danger of drugs and students' limited privacy in schools as a basis for its decision. The next case that we will review involved a school board hiring an independent security firm to conduct searches of district schools with a handheld metal detector. A team arrived at a Florida secondary school and noticed a jacket being passed to the back of the room. The team retrieved the jacket, scanned it, and found a gun. J.A. was identified as the owner of the jacket. The court identified this search as a random, with little suspicion, administrative search to further the purpose of keeping the school safe. The nature of the search was considered a minimal intrusion, and the interest of protecting schools from weapons and violence was immediate. The search was reasonable and not in violation of the Fourth Amendment. Two more cases to be reviewed involve field trip searches. One was a mass search of students' luggage prior to a field trip, which was deemed to be unreasonable because they lacked suspicion or reasonableness for the search. The second case involves a group of 140 students on a field trip to Hawaii, involved a principal's search of student rooms for alcohol, and also, again, deemed to be unreasonable because the principal did not have individualized suspicion of alcohol. This next case is definitely considered a landmark case. It involves a teacher who found a juvenile that we'll call TLO and another student smoking cigarettes in the girls' restroom in violation of school policy. The teacher took the two students to the administrator for questioning, at which the second student admitted to smoking cigarettes, while TLO denied the allegations. The administrator searched her purse and found a pack of cigarettes, cigarette rolling paper, a small bag of grass-like substance, a pipe, a wad of money, and a list of student names who supposedly owed money to TLO, and a letter to imply that she was dealing marijuana. The administrator contacted the local police station. They contacted TLO's mother, who transported TLO to the police station. While at the police station, TLO confessed to selling marijuana. TLO was found to be delinquent due to her age and was placed on probation for 1 year. Article 1, Section 5 of the Alabama Constitution of 1901 supplies a similar protection, that the greatest general and essential principles of liberty and free government may be recognized and established. We declare that the people shall be secure in their persons, houses, papers, and possessions from unreasonable seizures or searches, and that no warrants shall issue to search any place or to seize a person or thing without probable cause, supported by oath or affirmation. There are at least 4 repercussions that arise from improper unconstitutional searches. First, the evidence cannot be used in a legal proceeding against the student, and the student might be then absolved of responsibility even though all other signs point to guilt. The school official who conducts an improper unconstitutional search might be found liable for violating the student's constitutional rights and thus would be required to pay damages or surrender personal assets to the searched students. A particularly intrusive search may subject the school official to criminal charges or investigation by the Department of Human Resources, with presumptive placement of the school official's name on a list of potential child abusers. A particularly intrusive search may also subject the school official to common law claims for assault, battery, or violation of the student's privacy interest, again, intrusive on seclusion. To be reasonable at its inception, a school leader must be able to simply articulate a good reason why the search began where it did. The case involving TLO provided a good reason to search upon inception due to the smell of smoke coming from her purse. Even though TLO denied the allegations that she had been smoking in the restroom, the odor coming from her purse made it pretty obvious that she had been smoking. Therefore, the administrator had reasonable causes to search her purse. A key element in having reasonable suspicion is individualized suspicion, the ability to identify an individual who is the target of the search. That is why sweep searches, searches that might involve everyone in a room, including those who could not have been the wrongdoer, with those that might have been the wrongdoer, are problematic. There is no individualized suspicion. For a search to be reasonable at its inception, the first part of the TLO standard, the school official must have individualized suspicion. Exceptions to individualized suspicion. There are 4 exceptions to the requirement that you must have individualized suspicion for the search to be reasonable at its inception. Where joint use doctrine applies, where plain view doctrine applies, drug test for students and extracurricular activities, and where the search is considered reasonable due to emergent circumstances. If any one of these 4 exceptions exist, the school official does not need to have individualized suspicion for a school search to be reasonable at its inception. Exceptions to In closing, it is important for school officials to have the ability and authority to keep schools safe in order to support a wholesome, safe learning environment. However, it is also important to keep in mind that students have rights to privacy. Therefore, school officials must be very careful to follow every precaution when it comes to the search and seizure of a student or their property.